Judge Caldemeyer, my students are studying the court system and court procedures, and we have talked in class briefly about the structure of the federal court system, and I wonder if you could explain to us how the Indiana court system is structured.
All right. I don't know if it's best to start at the top and go down. I think I'll start with the trial court and go up.
Okay.
You have in Indiana, originally, historically had what, well, like this court, a circuit court. A circuit court is nothing more than a constitutional court. It came from the old historical, circuit court writer. Generally, there is one circuit court for each county. No county will have more than one circuit court, but in your less populated counties, maybe one circuit court judge will serve for 2 different counties. You've got 92 counties in Indiana, and I would estimate, and don't hold me to this, there are probably 70, 75 circuit court judges. So they're constitutional courts. They were set up when Indiana became a state, time of Constitution 1816. Then you have what are known as superior courts. These are legislative courts. These are nothing more than courts that were formed by the legislature after circuit courts were. They were set up to help with the caseload, population increases, et cetera, et cetera. In this county, we now have 4 superior courts, 1 through 4, and a circuit court. So we have 5 courts. But Superior Courts 3 and 4 were originally set up to be small claims courts by the legislature. However, they were changed. They still are. That still is part of their function. They are still small claims courts, but they also have been given jurisdiction in other matters by the legislature, including all civil matters. Probably divorces are, as we now call them, dissolutions, taking up 80 or 90% of the other civil matters they hear. They also have jurisdiction, limited jurisdiction in criminal matters, that being Class D felonies.
But you would tend to get a lot of criminal cases in your court?
An awful lot of criminal cases. I have probably tried 65 murder cases in my 10 years on the bench. Here in Delaware County, we've had a prosecutor, Mr. Michael Alexander, who has had no plea bargaining. Now, most people don't even believe this in the legal community, but I can show you my statistics, and they will verify this, is that there's no plea bargaining in major felony cases, those being murder, Class A, B, and C felonies. And I will probably try 20, 25 jury trials a year at the minimum, and because they don't plea bargain. And if you don't plea bargain, court's got to work a lot more. They got to try them and let the jury decide if they're guilty of that offense or any lesser included offense.
Okay. Well, let's get back to the civil versus the criminal caseload here. What percentage would you say of your caseload in the circuit court here is criminal versus civil?
Well, that's the question. The percentage, I'll probably have 50 major criminal cases filed a year, but I'll probably have 800 or 900 civil cases filed a year. However, probably, these are just guesses or estimates, 60, 70, 80% are dissolutions that are usually worked out, that don't have a jury trial, that it's not required. So percentage-wise, you have a lot more civil cases than you do criminal cases. But the criminal cases take more time because of no plea bargaining, the right to a 12-person jury. Civil cases, you have the right to a 6-person jury. That has been recently changed in the last couple of years, 3 years, I don't know, in Indiana. So you have a 6-person civil, 12-person still in criminal in Indiana. Now, you have other jurisdictional things when you say people just talk about criminal and civil. But you also have what is known as juvenile jurisdiction. I'll hear 200 or 300 juvenile cases a year. There's a total staff down there of 7 or 8 probation officers for juvenile only. You'll have probate matters. This court handles a majority of those, probably 300 years, probate of wills, et cetera, et cetera. You'll have mental commitments, that being probate and mental being civil type actions, the juvenile being criminal type actions. You'll have probably a couple hundred mental commitments a year. Guardianships. I don't know how many, 50, 100 maybe, I'm not sure. So still, the criminal takes the most court time because of the, right of trial by jury of your peers. You have a right to a 12-person jury. You have to appoint a public defender if the person is indigent. You have to appoint a public defender if the person is convicted, and advise that person of his right to appeal, and the state or the county pays for it.
Well, I take it that when the legislature created these superior courts, they did it for overload, so as population increases in a certain county, they're going to have more courts.
Sure.
Here in Delaware County, we have the 4 superior courts and a circuit court.
Marion County has 16,
County.
or Lake County 20. I'm not even sure how many we have. And they might even go to, and they do go to specialized courts. There you'll have one judge in Marion County, or at least one judge that's exclusively a juvenile judge. Just hears nothing but juvenile. You'll have several judges that are just criminal judges, hear nothing but that. You'll have several judges who are just probate judges that hear that, depending on the county that you're in. So yeah, to answer your question, very definitely, depending on the need, they go to the legislature, try to sell them that, and that's how it's changed.
In our class, we have students at remote sites. Some are in Fort Wayne. I'm not sure what county that is.
Allen
Some are
County.
up in Kokomo. Is that Howard County?
Right.
Some in Marion County in Indianapolis, and some in Bloomington, to mention a few. What about the small claims docket in counties like these?
Well, as I stated, when I was originally appointed to what is now Superior Court 4, it was at that time County Court 2, and created, I think, in 1975 by the legislature. And at that time, the governor, or the law for the first year of that operation, gave the circuit court judge the right to make the appointment. So I was appointed to that with the consent of the governor. But that was set up exclusively for small claims, and they probably, now they'll probably hear 4,000 to 5,000 cases each in small claims in each one of those courts, Superior Court 3 and 4 now, which were County Courts 1 and 2. But then later on, after 4 or 5 years, they added additional jurisdiction to that. Many of those things are settled without ever coming to trial, a lot of default judgments. I can't give you the percentages on default judgments and small claims actions down there. For that matter, I can't give you the percentage of default judgments here. I could make a rough approximation in here, but I haven't dealt with anything in small claims for 9 years, so I really do not know what the percentage is down there. And with the small claims action, you still there are no rules of evidence. The people have a right to represent themselves. However, you can bring a lawyer in, and many corporations or richer, I suppose, more affluent type clients do. But they cannot base their objection on rules of evidence, because that defeats the whole idea of a small claims situation where one can represent themselves, so they're not tangled, not tied down to rules of evidence. However, I'm sure they'd have a certain advantage. They should, if they've graduated from law school and practiced there. But rules of evidence don't apply in small claims actions.
Is the procedure then also relaxed in a small claims court case?
Yes.
So I take it it's more like an informal hearing?
Right. The judge, the judge, I assume, sits up here, but the judge will ask numerous questions. If the plaintiff or petitioner or person filing it hasn't gone into it and hadn't asked the right questions, the judge will ask them for information so they can base a decision. They may have forgotten something, or may ask them of the defendant or respondent also. But rules of evidence, like in this court, really prohibit the judge. It's not deemed appropriate to ask those questions, although sometimes the judge can ask limited questions, because then you're invading the province of the attorney. So that's kind of play it by ear in these courts with those things, but down there definitely, just to get the information before the judge.
Have you ever seen the television show called The People's Court?
Oh, yes.
Do you generally agree or disagree with most of the judges' opinions on that show?
I don't watch it. The kids do. After that's kind of like I don't watch it that much. I think it's based on factual, but they take odd cases that have public appeal and things like that. But he's an ex-judge. It's California. I think it's basically he follows the principles of law, but I think it's I suppose if I were sitting and hearing those cases, it'd be much more interesting than the cases you actually, the other 95 or 99% of the cases you hear, they're just run-of-the-mill. Divorce, how do you split up the property, et cetera, et cetera, et cetera.
In Indiana, how are the judges selected? Are they appointed or elected?
They're elected now to 6-year terms in the superior courts, the major superior courts, and in the circuit court. Now we have also 4 courts of appeals with 3 persons on that. We just got another appellate court. And
so we have 5 appellate courts?
No, we have 4 appellate courts and a Supreme Court, consisting of 5 members on the Supreme Court, 3 each on the appellate courts. These people are appointed by the governor, and it's a selective retention process right now. There's always a lot of talk about changing that for a 10-year term, at which time they're placed on the ballot on a yes or no, either retain this person or not. All have been retained. There's been no one who has been, so effectively it's almost like the federal system of having a lifetime appointment, really.
It would be comparable then to the federal circuit courts of appeal.
Basically, except that is lifetime, but this is every 10 years. But unless you, and like I say, nobody's ever been removed or not retained, and it'd be pretty difficult to be not retained.
Is the Indiana Supreme Court also appointed by the governor?
Yes.
Okay.
All right. Big controversy now. 2 appointments just came up, and that's been in the papers a lot of how these people are chosen, and been a lot of controversy about that.
And our Supreme Court has how many members? 5?
5. There was a bill to increase it to 7, but it didn't go through. They'll hear original actions. They used to hear on the criminal matters anything where a person was incarcerated for more than 10 years. It went directly, that appeal went directly to the Supreme Court, I think.
Do many cases from Delaware County get appealed to
Certainly. What have you got to lose if you have no plea bargain and you're convicted in a criminal trial, and you have a right, even if you're indigent, to have this court appoint you a public defender or a person that represents you for free? They're all appealed. I can't think of any that are not appealed, so that's another expensive process.
What about in civil cases? What do many of those get appealed to the appellate courts?
Oh, no, well, percentage-wise, I'm not sure. Maybe 20%. If it's a big case, a multi-million-dollar case, sure. Somebody loses, they're going to appeal it. Your dissolution cases, no.
Right.
Because judge has wide discretion, and most of those are affirmed because if not, the Supreme Court would end up, or the appellate courts, retrying the case. They don't have time to do that and don't want to do that. But percentage-wise, I really couldn't tell you. Certainly not any more than 10, 20%, something like that.
Okay. I think that gives us a good idea of how the Indiana court system is structured. Let me ask you a couple of questions about what it's like to be a judge, and then some questions about some procedural things we talk about in our textbook. Caldemeyer, a very small percentage of people in our society ever become lawyers, and only a few of those lawyers ever become judges, so it seems that you and your colleagues are in a rather unique position. How do you view the role of the judge in society, or in particular your role as a judge in Delaware County?
Well, it's a difficult question. My role is to help ensure fairness, whatever that nebulous concept may consist of. You have rules of evidence, which I am bound by. I think people get the misconceptions that judges, for some reason, well, maybe in the federal court they are omniscient and all-powerful and all-present. State courts, no, and not even in the federal courts. We have to operate under rules of evidence. We only have so much discretion, and I would suppose you could, here again, this is a rough breakdown, that you could say, maybe just in 2 or 3% of the cases do we have any discretionary judgment, or can we exercise any discretionary judgment. The rest of it's pretty much, there it is, here are the rules, you got to follow the rules. Now, I'm excluding small claims, of course, from that. And you have to follow those things. you know, the only way law has changed is it's just changed by two methods, either the legislative, and then that's still reviewed, but for the constitutional content, or by precedent. And when you go to law school, you study all these precedents. Well, but the precedents that are set, you know, are like 1 in every 10,000 cases, those precedents that are set. The rest of the time, you're following what the law is, because in order to set a precedent, you're going to have to try it in the trial court level, you know, reviewed by the appellate court, depending on whether they affirm or reverse that, goes to the Supreme Court. Then it may go to the switch over and go on to the federal court system. So I suppose you're more of an umpire, and you have the rules that you're governed by. Many times you may not like a decision in a particular case, but it's to apply to, it's a rule or a system of justice. So you can't intervene, or you're setting yourself up as God if you do it too much. If you intervene and place your own judgment in there and try to do away with the rules of evidence, that's not part of the system. I mean, it's done sometimes. That's where precedent comes from, obviously. But I'm speaking of the majority of the time. I suppose you're more of an umpire.
I was going to ask if it's difficult to keep your own personal biases out of your decisions.
I think, yes, it was initially. I think this is my 10th year, the longer you serve, I suppose it's like anything else you do in life. You may have them, but you've seen juries work. There have been times you've been appalled or shocked by their decisions, but overall I would say the jury system is as good a system as any that I can imagine. But I think as you get older, that's not your role. You can have personal opinions, and if they're too strong, you disqualify yourself from the case.
We've talked in this class in a previous lecture about the development of the equity courts.
Mm-hmm.
And I wondered if you, in deciding a case at law, are able to use equitable principles.
I would hope so. I hope that Charles Dickens didn't write that the law is an ass, the law is an idiot. I think that's common sense, is equity. I mean, you can take all kinds of courses on it, but you still have to fit it in pretty much or almost completely with the rules of law, but there are ways to do that. But yeah, that's what a court is to do, is equity. Sure.
Does it ever happen after you render a decision, say in a civil case, let's not even talk about criminal cases, that the litigants or the loser in the case becomes abusive or unruly towards the other litigant, or perhaps even towards you? And if so,
well, if
what
they do it toward
in that
me,
case?
they'll be down in jail for contempt for 60 days without any bond. If it's done in the courtroom, that's a direct contempt, whether it's on me or on one of the attorneys, because they are technically officers of the court, and that just cannot be tolerated. What happens after that, they hit the halls or the streets, I'm really not sure. But no, you'll have people who may not talk to you for the rest of your life, or you may have people say a lot of bad things about you, but you're going to have that anyway, regardless of what you do in this life. No, I haven't had much trouble with that. And even with murder cases, you receive some threats every now and then, but it's kind of like the dog that doesn't growl. As long as he's growling, you're pretty safe. The dog that bites you is the dog that does not growl and sneaks up on you and gets you.
Okay. I would guess that given the diversity of the types of cases you hear in your court, that this is a fairly demanding job, both mentally and physically. Are there any corresponding rewards or satisfactions you get from this difficult work that you're engaged in?
Well, salary, Indiana ranks 49th out of 50 states as far as pay.
That's not very satisfying.
Well, but it still pays more than a professor, which I was, or an instructor at Ball State.
Okay.
Yes, you get, obviously, you'd have to get some rewards. When you see a kid you've had as a juvenile that wasn't reading, and you forced him into a reading clinic and see that he's made something of his life and is not in prison, yeah, that's real rewarding. Or I suppose even with the limited amount of discretion that you have, at least you have some discretion. You know, when you sit on TV and something bothers you, at least you're going to have some say, whereas the general public really doesn't have that much of a say. That's a reward. But I think you reach a burnout stage It's often been said of criminal trial lawyers that they only have so many trials in them. I'm not so sure that it's not applicable to judges also, even though we're not active participants. We have to anticipate what they're going to bring up. We have to make the rulings on that. A lot of people think a judge just sits up here and does nothing, but usually a judge is doing his best job when there aren't too many objections. The lawyers know him, they know if he's up on it, things like that. So they know what they can get by with and what they can't, and what the judge is going to allow to go on before a jury and what he's not.
Let me ask you a couple of questions about procedural aspects of an Indiana trial. Do we have the pretrial conference in the state?
Sure,
and
we
to
do.
what extent is that used as a means to settle cases?
Well, you have pre-trials. I think it depends a lot on the individual judge. I use it because in Indiana, criminal trials take precedence because a defendant has a right to be tried within 60 days now, unless they've filed for continuance and things. And I try to get the lawyers in. I say, this is a pre-trial conference. These are the issues. Narrow them down. Let's get our preliminary instructions together and try to force a settlement, because many of your civil trials will be settled and some of your criminal trials will be, even with no plea bargaining, because I think the defendant feels that, well, if he comes in and just lies to that judge or a jury, that the judge is going to take that into consideration with sentencing. And if he's looking at 6 to 20 and he sat there and bold-faced lied, whether the judge says he took it into consideration or not, he can justify it by other means. So you'll get some pleas even if you don't have any plea bargaining. But I don't think it's as much of a hammer as it is in the federal system. But then I haven't dealt with the federal system personally for 10 years.
There are three procedural aspects or motions that the authors of our textbook talk about, and students usually have questions about these. Let me ask you if we use these in Indiana. One is the motion for summary judgment.
Yes.
We do use that. Is it granted very often?
No. Well, it is, when I say no, I'm referring to like a jury trial. If the evidence is presented before a jury, in Indiana, in criminal law, a jury is the trier of both the fact and the law. The judge just gives instruction. Georgia and Indiana are the only two states that's true. In civil actions, they are the trier of the fact and not the law. And that's usually what it is in most states with criminal. So I think most judges feel that here you've brought these people in, they've sat here for 3 days. In a civil trial, it only has to be proven by a mere preponderance of the evidence. So unless it's just so totally outrageous, you're not going to grant a motion for summary judgment or a directed verdict. Now, let's say that your next question, I'm sure, is going to be, well, how about if it's in a criminal trial or a civil trial, and the judge sets it aside as an excessive verdict, for example, in a civil trial, or doesn't conform to the evidence or something in the criminal trial. I've never done that. I have granted motions for summary judgment, several, in criminal and or directed verdicts. They're the same thing, really, in both civil and criminal. But I'd say the percentage is 1 out of 1,000, 2,000. Very, very rare.
Very small. What about the judgment notwithstanding the verdict? Do you ever hear that come up?
You hear it. Lawyers will make motions to that effect, but here again, I've never done one. I've never had one that I've done. There are plenty that, I mean, there's several that have been done throughout the state. But, you know, you're really treading on thin ice there. You're taking here you've called a jury in, they've made their decision, the judge has had a chance for a directed verdict or summary judgment, he didn't grant it, it goes to the jury, they've reached their verdict. And particularly in Indiana, in a criminal case, if the trier of both the law and the fact, that's an instruction you give them. I don't particularly like that instruction, but here again, it's not my discretion. I have to give that instruction because that's a law in Indiana. I can think of none that have been done in Delaware County. There may have been some. But no, I can think of none. I've read some in the paper, you know, in other courts that have happened in Indiana, but not Delaware County.
How many jurors sit on an Indiana civil jury?
6 now. It used
And
to be 12.
12 criminal?
12 on a criminal. Usually have an alternate 13th or a 7th in case somebody gets sick, so you don't have to go through that boring process of selecting a jury again.
Does an Indiana civil jury verdict have to be unanimous?
Yes.
Okay.
Civil trial, it expedites things a lot. You get 6 people in here, they can form a rapport very quickly. It takes 12 a lot more. They're scared because they're in a courtroom, this, that, and the other. And in a civil trial, the burden is just by a mere preponderance of evidence. In a criminal trial, it's beyond a reasonable doubt. Well, to convince 12 people beyond a reasonable doubt is a very tough thing to do. But nevertheless, we operate on the premise, and I agree with the premise in American society, that it's better to let 9 guilty men go free, or persons, than to convict 1 innocent man. And you're going to pay your money and take your choice on something like that.
The final question I wanted to ask you is a question that I get asked almost every quarter I teach this course, and I think you're probably one of the best people I could think of to ask it, since you've been on the bench for 10 years now. But how does a judge, in any kind of a case, whether it's civil or criminal or whatever, determine who's telling the truth when the parties have got versions of the facts that are completely different? You have witnesses whose testimony is diametrically opposed. How do you, as a judge, determine who's telling you the truth?
Common sense, but let's break it down to this. Number one, if it's a jury question, either civil or criminal, that's up to the jury. The judge doesn't make that determination, so that takes it out of his province. There are instructions that say you are the sole judge of the credibility evidence, etc., etc. It's a big, long instruction. But so that's taken out. But if you go like your divorce cases, it's or dissolution. That's a nice name for divorce. Same difference. Common sense. I think it goes back to your equity question. I think you develop a feel for that. Some people have more common sense than others initially anyway. You develop a feel for that over the time. You've heard so many stories. Oh, you'll hear a new one every now and then. You're glad to hear one because you get bored with the same old lies you hear before. But you have a lot of discretion. There are ways that you can check that out. But no, you're not God. You don't always know. There's always somebody who can slip one past you, but nevertheless, they're man's laws. Of course they're fallible. Someone has to make that determination. There's no magical answer to that.
Okay, thank you. Any final remarks you'd like to make?
No, not really, other than the comment that I alluded to earlier about this is my 10th year. I got 3 more. I don't know that may be enough, or definitely another 6 years would be enough, because it's a lot of pressure. The only time you see people are when people have problems, and you get a very distorted view of people. You become very distrustful. The only happy time in a courtroom in Indiana would be an adoption, because somebody's getting a break. But even that, even an adoption is sad, because somebody's died or the parents have given up this child before. But every other instance, criminal, bankruptcy, that's federal, but bankruptcy, divorces, probates, somebody's died or is in trouble. So you see people at their very worst, and it gets depressing. Mental, yeah. But it goes with the territory, and I suppose it's like Harry Truman said, if you can't take the heat, get out and do something else.
Judge Caldemeyer, I'd like to thank you for your very insightful comments. I think this has been an interesting interview, and I know you're busy. You've got some people coming in here as soon as we leave for a hearing, but I do thank you for your time.
You're very welcome.